Hello everyone, my name is Sienna McCrae and I chose to discuss freedom of speech and the press. Relevant constitutional provisions regarding freedom of speech in the press include the First Amendment, Patent and Copyright Clause, Commerce Clause, Fifth Amendment, Basket Clause, 13th Amendment, Equal Protection Clause, 19th Amendment, and 26th Amendment. The First Amendment includes the two rights I'm discussing today, freedom of speech and freedom of press. Within freedom of speech, hate speech is protected. However, slander, libel, or obscenity, fraud, child pornography, speech that incites lawlessness or illegal conduct, speech that violates intellectual property, true threats, and advertising can all be limited by the government. Freedom of press, similar in some regards. Defamation is restricted, so is obscenity, and whistleblowers are often unprotected. Unfortunately, the government can still create barriers to the access of information and constraints on certain media outlets. The Patent and Copyright Clause, found in Article 1, Section 8, Clause 8, reads that Congress has the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Basically, it can protect the individual properties and identities of others, as well as any thoughts and ideas they have through legal processes. The Commerce Clause, found in Article 1, Section 8, Clause 3, reads that that Congress has the right to regulate commerce between the country and foreign nations, the states, and Indian tribes. This is most often seen in advertisements, internet access, and some other things as well, and can all influence our speech and the media that we receive. The Fifth Amendment, while you wouldn't really think about it, has a lot to do with freedom of speech because it gives you the right to not say anything at all. The government can't force you to say things against our will without any legal protection or guidance. The Basket Clause, also known as the Necessary and Proper Clause, the Elastic Clause, Sweeping Clause, or Coefficient Clause, is found in Article 1, Section 8, Clause 18, and states that the government is allowed to make laws that can be considered to be necessary and proper for the execution of the federal government's enumerated powers. A pretty good example of this would be the creation of the NSA. That was necessary and proper at the time for terrorist things and national security threats, and it monitors our speech and can prosecute us or investigate us based on anything we say. The 13th Amendment, while it didn't give total rights to the Black population or the indentured servitude population, it did allow them to seek new opportunities and find their voices within society, and eventually it led to the civil rights movement nearly 100 years later. The 14th Amendment states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Not shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of laws. Essentially, it guaranteed anyone born in the country that they had the same protected First Amendment rights as others. And it's often used in a lot of court cases now to help add to the First Amendment right when deciding whether or not to rule in favor or against plaintiffs. Voting is a huge part of our First Amendment rights. It's a way we can speak out. And so the 19th and 26th Amendments both are huge constitutional provisions in regards to freedom of speech, as the 19th allowed women the right to vote, and the 26th gave those 18 years and older the right to vote when originally it was 21. That was because of the draft that was going on at the time, and people thought that If you can give your life to your country at the age of 18, you should be able to vote for representation and for laws at the same time. We're now on to the Supreme Court decisions and their relevancy to freedom of speech and freedom of the press. Here's a timeline of all the court cases I'll be going over. Schenck versus the United States, Gitlow versus New York, New York Times Company versus Sullivan, Brandenburg versus Ohio, and Hazelwood School District versus Kuhlmeier. The first case I'll be discussing is Schenck versus United States. It was decided on March 3rd, 1919, in which SCOTUS, or the Supreme Court, unanimously, also known as per curiam, ruled that the Espionage Act was constitutional and sustained the defendant's convictions. His convictions being that he was a socialist that was distributing pamphlets claiming that the draft during World War I was a violation of the 13th Amendment, which banned involuntary servitude and implored the public to start dodging the draft. He had been charged with and convicted with conspiracy to violate the Espionage Act of 1917, and obviously Schenck appealed to the Supreme Court on the grounds that it violated the First Amendment rights. Congress now officially, because of this ruling, had the right to restrict any expression which posed a clear and present danger to national security. Gitlow versus New York was decided on June 8th, 1925, after socialist Benjamin Gitlow was convicted of conspiracy to overthrow the government under New York's criminal anarchy law after distributing a left-wing manifesto that urged people to establish socialism through strikes and class action reform. Gitlow appealed this decision after no action was ever taken by any of the people he passed out pamphlets to, and he thought it infringed on his rights. So the court had to answer the question, can a state punish political speech that explicitly promotes an overthrowing of the government? They ruled a 7-2 decision that the First Amendment did not protect Gitlow, but that the Bill of Rights, originally only meant to be used against the federal government, could now be implemented against state and local government. After the New York Times debuted an ad for donations that would contribute to the defense funds for Martin Luther King Jr. in the 1960s, a public safety commissioner named L.B. Sullivan found that there were a lot of small factual errors, which he deemed to be libel, and per Alabama libel law, sought punitive damages and asked for the ad to be taken down. In the end, he was awarded $500,000, and then New York Times appealed it. The Supreme Court had to answer the question, was Alabama's libel law violating New York Times Company's First Amendment right to freedom of speech and the press? They ruled unanimously in favor of New York Times, stating that libel of a public official must have proof of actual malice, which is extremely hard to actually prove. And since then, because there was no evidence in this case, since then, no federal official has won a libel appeals case against a news outlet. Decided on June 9th, 1969, Brandenburg versus Ohio dealt with a Ku Klux Klan member or leader named Clarence Brandenburg, who was convicted under Ohio criminal syndicalism law that, after speaking at a Klan rally, the law made certain forms of anarchist advocations such as crime, sabotage, terrorism, and assemblies illegal. Brandenburg thought that his First and 14th Amendment rights were violated, and the Supreme Court voted unanimously that Brandenburg's rights were infringed on under Ohio law and initiated a two-pronged test to evaluate speech acts. One, it can be prohibited if it is directed at inciting or producing imminent lawlessness, or two, if it is likely to incite or produce such action. Hazelwood School District versus Kuhlmeier was decided on January 13th, 1988, after a principal at one of the schools decided to delete some of the publications or articles within a publication of the school student-run newspaper. The Supreme Court ruled 5-3 in favor of the school. First Amendment did not require schools to promote particular types of speech from students, and it is the school's responsibility to discourage speech that is inconsistent with the shared values of a civilized order. Now on to relevant legislation. The Espionage Act of 1917 that was previously discussed when talking about Schenck prohibited obtaining information regarding pictures or copying descriptions of any information relating to national defense or national security. It also added criminal penalties for anyone avoiding enlistment or causing any sort of insubordination within the military. The Alien and Sedition Acts of 1798 made it illegal to print harshly critical newspaper stories about the president or other national officials. Thomas Jefferson called the act an alarming infraction of the Constitution and pardoned those who had been convicted once he became president. The Sedition Act of 1918 made it a crime to willfully utter, print, or write or publish any disloyal, profane, scurrilous, or abusive language about the form of the government in the United States, and or to willfully urge, incite, or advocate any curtailment of the production of anything necessary or essential to the prosecution of war. The Communications Act of 1934 allowed Congress to regulate broadcasting and create the Federal Communications Commission, also known as the FCC. Broadcasters had to be licensed and required to be impartial in political coverage. Basically, if they gave an ad spot to one candidate, they had to give the same amount of ad space to another one. Section 230 of Communications Decency Act was in 1996 and was Congress's first attempt to regulate digital pornographic material. Contrary to the rest of the bill, Section 230 is the only thing that actually protects free speech and says no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information or content provider. SOPA of 2011, also known as Stop Online Piracy Act, was a bill that authorized the Attorney General to seek court orders against websites committing or facilitating online piracy, and it would require the owner, operator, or name registrant to cease and desist. It was never passed, but it's relevant. The net neutrality laws during the Obama administration typically prevented internet providers from favoring certain websites over others and gave small websites an equal chance of viewership despite ad spaces. It was a little hard to do the executive orders because anytime you look up executive order free speech now, the only thing that pops up is Trump stuff. So I chose the two most recent presidents, President Trump, President Obama, and some things that they did revolving around free speech and their executive orders. President Obama had an executive order proposal that never seemed to go through back in 2011 called the Disclosure of Political Spending and Government Contractors. And it would have required any bidder for a federal contract to disclose any and all financial contributions to political candidates and third-party groups, including the NRA or CAP, and political contributions are regarded as speech. Money is regarded as speech, and so that's why it's included. President Trump had several executive orders within his last 2 years of being president regarding free speech. The first one being Executive Order 13864 about college and universities. It seeks to promote free speech and open debate on college and university campuses. Another one, 13943, regarding TikTok and WeChat, which banned or attempted to ban the consumption of WeChat or TikTok-based apps for national security purposes. And the last one being 13925, online censorship, which protects against corporations, big tech, censoring you. And here are my works cited. And that's it. Thank you.